Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. In this episode, we're going to talk more about IP ownership. We're going to talk about securing IP ownership when working with partners, employees, and contractors. Do you own a socket wrench? I have done many projects with a socket wrench, and one of the innovations for the socket wrench was invented in 1965 when a Sears clerk invented a socket wrench with a button that releases the socket so you can change the sockets with one hand. I've used that plenty of times. Sears agreed to buy the patent rights from their employee for $10,000 and then went on to sell millions of socket wrenches with the button release feature. When the inventor saw how widely the patent was sold, he sued Sears, saying they misrepresented the value of the patent when they bought the patent. The lawsuit lasted for 20 years, from 1969 to 1989. When the case finally settled, it had gone up on appeal, and there was a judgment against Sears, and then it was overturned and it was sent down for a new trial, and they started the new trial and they said, we're not going to do this again, and they settled. I don't know what the amount is. That was confidential, but Sears went through 20 years of a legal battle because of the way things worked out for them. So clear agreements around intellectual property can prevent millions of dollars in lawsuits and costs, and even save projects that otherwise might be abandoned because of the risks around IP ownership. Intellectual property has defaults for ownership, and this is where you need contracts so that you don't end up with the default when it doesn't work for your company. So the default for trade secrets is that, or confidential information, the default is if it isn't kept secret, and if you don't have an agreement with somebody to keep it secret, or if somebody didn't breach your security and actually stole it by hacking or physically going in, if you don't have those situations, you don't have any IP rights, anything you can sue on. So you have to have agreements to have trade secret, or if you're the only one that knows about it, you have to have security around it. But that usually doesn't work in business, to be the only one who knows. So you got to work with others. You got to share your secrets so you can work as a team. The defaults for patents are that patents are owned by the inventors unless the inventor was an employee, not a contractor, and that employee was working within the scope of their employment. So in that Sears case, he was a clerk in a store. So his scope of employment was not engineering. It was not creating an innovation for a tool. And he came up with that. And since, he came up with that on his own, it wasn't something that Sears owned. So they went ahead and bought it. But their agreement didn't stick, at least according to the courts. There was enough of a battle that they couldn't just get the case to go away. So the default for copyrights, that's creative works. Copyright protects authorship, videos, pictures, paintings, websites, content that's put together, written, spoken, recorded. The default is the author is the owner unless the creative work was created by an employee within the scope of their employment. And that is not a contractor again. It actually needs to be an employee, or someone who has that level of control that they're really treated like an employee. So it gets messy, especially when two companies work together to create new IP if there's not a clear agreement on who will own the IP. And this happens. Companies say, you have one expertise, we have another, and we see how we could combine those expertises together and make something great. If there's not a clear agreement, then it gets really muddy, especially when the two companies don't make it clear to their employees that our company has some trade secrets. When you're discussing and innovating with them, do not disclose our trade secrets. Don't bring them into the room. Don't make them part of this innovation, because then you've likely lost control of your trade secrets. Another issue that I just heard about this week on keeping control of trade secrets is ChatGPT. ChatGPT is learning. Every time someone gives it a task, it learns, and it learns how to do it better. It asks for feedback. How did I do? Sometimes when you say, I didn't like that answer, give me a different one. And it says, was that better? So it's constantly learning. And that's why it's called artificial intelligence. There are companies who have trade secrets, for example, software code, modules, and they've discovered that somehow somebody put in their trade secrets into ChatGPT, and then ChatGPT is helping other people write software code, and their code, their innovation, their ideas are in that. So they've lost control. It is going to be really difficult if they even can pull that back and make it a trade secret again. So that's a new development, a warning that you may, what you really need to do is not just create agreements, but have a clear understanding with employees, contractors. If you've got confidential information, tell them you can't use an open AI model to help you with this, to help you explain it, draft it, because you've got to feed it the trade secret to have it help you write. So unless the company has its own internal closed AI, not an open AI, you're going to have to you're going to have to not use that. That needs, and that's something that's now companies are going to need to update in their manuals and potentially in their agreements as well, and in their training. So you want clear agreements with all employees and contractors about ownership of intellectual property and use of confidential information. You also want to negotiate clear expectations when doing a joint research project. And so the question is, okay, you've got these two expertise, this joint research, who is going to own the result? Oftentimes what actually makes the most sense is to have, if you're really going to create something new, form a new company, and both parties are part ownership in that company. If that's what makes sense, or if one company's going to own it, you really need to know who's going to own what we work on before we work on it. This often becomes the hardest when, things are really successful initially or has great potential. And then people are like, well, who gets to benefit from this? Who gets to use it? Who gets to own it and monetize it? And when you're putting together agreements with employees, contractors, partners, don't be greedy. There's an old saying, pigs get fat and hogs get slaughtered. And if you have fair deals, then you're gonna get what you need. You're gonna benefit from your hard work. But so in the Sears case, potentially it sounds like that Sears got greedy. They got and they got a 20-year lawsuit. So they made, it sounds like, at least these are the allegations based on a Washington Post article. Yes, it was an article in the Washington Post where they reported on the lawsuit that in 10 years' time, Sears sold 19 million of these wrenches. Now, if you consider that if they had made an agreement to pay the inventor 5 cents for each one that was sold, then that 19 million would be of number of wrenches sold in a 10-year period, would have given him about $1 million. Now, this is from 1965 to 1975 time frame. So $100,000 a year for 10 years in those days, those dollars, that would probably make him a very happy, no need to file a lawsuit. I'm benefiting. Life is great. And then I'm sure would have spent less money than all the attorney's fees for 20 years, finally settling it, and all the headache that was involved and all the time it took away from people in the business to have to deal with that instead of dealing with the new innovations, new projects, figuring out what the company needs to grow. So if you've got it, you need to be working with people. Schedule a free consultation to discuss your intellectual property agreements and plans. And our next episode, we're going to cover the role of contracts in IP ownership and navigating joint ownership. We're going to go a little deeper than we have in this one and talk about what do those contracts really need to have and what do they need to say? What is the purpose of those contracts and what is that relationship going to look like? Thanks for joining me. This is Wayne Carroll with Leveraging Inspiration.